Texas versus Kendrick Cuba, cause number CR 23-28815 and CR 24-28891. And sir, you are Mr. Kendrick Cuba, correct?
I am. Before we get started, I'd like to point something out. I was picked up on a
Okay, Mr. Cuba, I need to go ahead and get you sworn in, and then we're going to just one moment, and then we're going to move forward with the pretrial. So just bear with us, but we're going to have you raise your hand to be sworn in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. You may put your hand down. All right. For the attorneys, this is our pretrial. We have several motions that have been filed. We're going to step through those. But first, is the state ready to move forward on the pretrial?
Yes, Your Honor.
All right, Ms. Wozniak.
Before we go,
Mr.
I tried to file her. I don't want her on me as a trial attorney or nothing. If we're going to trial, I do not want her as my attorney because I have.
Mr. Cuba, I'm going to go ahead. Mr. Cuba, we've already addressed this, and I've already denied your request. Okay, Mr. Cuba, I've muted you. We're going to address this momentarily. Ms. Wozniak, do you need a breakout session with your client at all?
No, Your Honor.
Okay, just one moment. Let's go ahead and address the pretrial. Please listen to the motions and the things that we're addressing. Okay, from the state's perspective, I see motions filed on the 7th. Were there other motions that the state had filed earlier?
No, Your Honor, not that I do not believe so.
Okay. Now I'm going back and looking at some of the earlier filings, and I want to point out that on July 29th, Mr. Cuba filed his own motion to dismiss. Two things. One, there's no hybrid representation. And number two, the information that he has in this motion, Mr. Hazelton, I'm just going to give you a chance to look at that. Ms. Wozniak, was there anything here that you had wanted to urge that you believed legally was an option?
Not at this time, Your Honor.
All right. So this was making requests about a speedy trial. The court has set the matter for trial. We are addressing the pretrial now. I want to move forward. After that setting, we did address having the trial set, having the cases set for trial. And the state had their offers on the record, and the defendant declined those, which is his right. Then we did see another pro se filing by Mr. Cuba as it related to cause number CR 23-28815. And this is where Mr. Cuba is of the opinion that this is a Class A misdemeanor, family violence assault.
Before we go any further, buckle up, because this case is not just about paperwork or technicalities. This is a textbook example of what happens when someone refuses to take accountability, misunderstands the law, and then decides the courtroom is the place to argue feelings instead of facts. Today's defendant, Kendrick Cuba, isn't confused about what he did, he's confused about why the system won't let him get away with it again. And that distinction matters. What you're about to see is a pre-trial hearing where a judge calmly, repeatedly, and patiently explains something that should not be complicated. Prior convictions change everything. But instead of listening, the defendant talks over the court, files motions he legally can't file, and insists the system is wrong, not him. Pay attention to how quickly this hearing stops being about legal strategy and starts becoming about control. Watch how the judge maintains composure while laying out the consequences that are now very real. And most importantly, listen closely to the moment when it finally clicks just how much time this man is actually facing, because when that realization hits, the tone of the entire
or attempted effort to file a motion to dismiss. This is the same information I have received from Mr. Cuba multiple times. He is of the opinion it's a Class A misdemeanor, and the state has indicted as a felony. So I want Mr. Cuba to know we're well aware of his position on this, and the state is well aware of it. And importantly, his attorney is well aware of it. All right, now we go forward and we're looking at September 9th. And we have either a different or the same motion. Okay. Yeah, Mr. Cuba, if you'll listen to the information, you'll find it helpful to you. And it doesn't, you're showing us a document that looks like the bond where the original bond was set on a Class A misdemeanor. And then when it gets filed with the DA's office, they have the ability to look at prior convictions if there are any. And then the state can take action to enhance it. And I believe we went over this multiple times, but we're going to go over it one more time so you have the benefit on the record of understanding. Let's look at that indictment so you can see what the state has in fact addressed, because this is the indictment the state's moving forward on. And so when you look at this, you're going to see, we're going to make it a little larger because there's a lot of words on here. If you'll notice, it's entitled Assault of a Family or Household Member, but with previous conviction. All right, so that tells us that it was a Class A misdemeanor, a pinning her to the ground and a striking of her. But previously, the defendant had been convicted of family violence on April 26, 2018 in the 336 District Court in cause number CR 17-26281. So when you pinch somebody, slap somebody, hurt somebody, and it would otherwise have been a Class A misdemeanor, but you have a prior conviction for family violence assault, then that becomes a higher level offense. In fact, it becomes a felony 3, 2 to 20. And then we're looking at the enhancement provisions, and Mr. Cuba has also the 3 enhancements, and effectively they're sequential. So this makes the felony 3 that he believes is a Class A assault actually punishable by a minimum of 25 years or a maximum of 99 years or life because of the number of prior convictions. All right, we went over that previously, but we are at the pretrial, and I want to make sure that that's been refreshed for the benefit of Mr. Cuba. We do have a bond violation at some point by him in 2023. A failure to appear November 9th, 2023 is reflected in this offense or this cause number. And now we're moving forward. We've covered those motions to dismiss. A lot of filings by the defendant on his own behalf. We do have a competency that was done. He was deemed to be competent by the doctor and the court so found, and that was in June of this year.
Right here is our first red flag, and it's subtle, but important. Before the pretrial even begins, the defendant tries to interrupt, redirect, and control the conversation. That might not sound serious, but in a courtroom, it tells you everything about mindset. Judges expect defendants to listen first, speak when allowed, and respect procedure. Mr. Cuba does none of that. Notice how the judge doesn't escalate. No scolding. No sarcasm. Just firm boundaries. This is judicial patience at work, and it's deliberate. Every interruption is being noted. Every attempt to derail the process quietly chips away at credibility. Also worth noting, being sworn in is not a formality. Once you're under oath, every statement matters. The fact that the defendant immediately starts pushing back instead of paying attention suggests he believes this hearing is about negotiation, not explanation. And that misunderstanding is going to cost him, badly.
Evidence.
Yes, Your Honor, I believe that would be the first of the state's filing.
Okay. So let's go over this. What exactly is it that you have in the way of video evidence that that you intend to offer?
Your Honor, that would be body cams dealing with the witnesses during the day of would be my intention, and I believe there would be a 911 calls would be what we were looking at. I believe me and Ms. Wozniak will be able to work this out. We haven't been able to conference on the issues of AV, but I believe we would be able to address these, and if there was any issues, if we needed, we could further press the court for, but I do not believe that would be an issue at the moment, Judge.
All right, Ms. Wozniak, your position, is this your understanding?
Yes, Your Honor. Mr. Hazelton and I will further conference about the admissibility of those before trial. And if there are any issues, address the court, but I don't foresee any issues, Your Honor.
Okay. So let's out of an abundance of caution, give you all a date certain. The trial setting is October 28th, and this is our top case. So Mr. Cuba's case will go to trial.
Judge, I thought our trial date was November 18th.
I'm sorry. I stand corrected. Yes, November 18. I was thinking about my next trial date. You're right. The next one here is November 18. So we've got a little more flexibility on when we could select a pretrial date on the audiovisual, just to make sure any agreements y'all have are actually, I'd like to have those memorialized before we get picking the jury.
May I propose November 6th? That'd be a Wednesday, so 9 a.m. I would believe that we would be done with the trial the prior week before, and I believe that would give us sufficient time.
Ms. Wozniak?
That works for me, Judge.
All right, that'll be a 9 a.m. setting. So, Mr. Cuba, we're going to have a 9 a.m. setting just for the audiovisual, and your attorney will have the benefit of going over this information with you. Ms. Wozniak, would it be beneficial at all to have the ability to go over that here in the holding cell on video, so that Mr. Cuba had the benefit of being here and going through that, we can memorialize all that on the record?
To have him watch the video while he's at holdover, Your Honor?
Yes, because I don't know what kind of cooperation or support y'all are getting from the access that you have to show him the discovery at the jail. This would
Judge,
just give you a time frame, and then we would have the benefit of getting all that.
This section is where a lot of defendants get tripped up, and honestly, it's where armchair legal experts online tend to get loud and wrong. Mr. Cuba keeps filing motions on his own while also having an attorney. That's called attempting hybrid representation, and courts do not allow it. You don't get to play lawyer when it suits you and then fall back on counsel when it doesn't. The judge is crystal clear here. Your attorney is aware of your position, the state is aware of your position, and the court is aware of your position. Filing the same argument repeatedly doesn't strengthen it, it weakens it. This is also where we start seeing the real issue. Mr. Cuba isn't arguing facts, he's arguing labels. He wants the charge to be called a misdemeanor because the word felony carries weight. But the law doesn't care about what you want it called, it cares about your history. And that history
There'll be a jury. Sir, there will be a jury selection on November 18, and you'll be here for that, but we're also bringing you in on November 6. We're going to have you reviewing all the videos on November 6 here at court,
Right.
okay?
The ones you're fabricating, right? Why do you keep putting me off month after month after month after month? What you're doing is you hold me in this jailhouse because you're really a racist, and I don't like being up under you because you are Joshua Reed's mother, Joshua Reed's Blackman's mother, and you are the same judge who gave me 10 years 10 years ago and recommended I do not recommend parole because I had a drug case, not an assault case, and you're putting all these charges. You steady putting me off. This is a Class A misdemeanor, and you're trying to do all these crazy enhancements from 25 to life on a Class A misdemeanor.
Okay, Mr. Cuba, first of all, I'm not that, Mr. Cuba, please listen. I've muted you. I am not that person's mother. I didn't do anything with contesting anything with parole. I don't know what you're talking about. If what you mean is the offense for which you were convicted affected your parole, that would be a different issue. And this court would have signed it. And yes, I am a judge who's previously handled your case. So, all right, we're going to then move forward. Let me memorialize on the face of the state's motion to produce that video evidence of this setting. Okay, the next filing I see, and I'm going to go ahead and just screen share this so that Mr. Cuba can see the documents that we're talking about. And this is the state's motion in limine. And Mr. Hazelton, is there any reason to not take this up at the time of trial? Or do you have some? Okay. All right, then we have also filed the state's request for disclosure of experts 20 days prior to the beginning of trial. Ms. Wozniak, any objection to this motion?
No, Your Honor.
All right, the next motion we have filed is a defendant's motion. And this is the defendant's motion, a formal motion for discovery. Ms. Wozniak, is there anything else you wanted to address on this filing?
No, Your Honor.
All right, and Mr. Hazelton, has the state provided the discovery?
Yes, Your Honor, we have complied with 3914 and I've provided everything. If anything is to come in, I will timely provide it over to Ms. Wozniak.
Okay, and then I'm just going to encourage the parties to make sure that also on that November 6th date, it's another opportunity for Mr.
This is the heart of the case, and if you're watching at home wondering how something suddenly becomes a felony, listen carefully. The charge itself didn't magically change, the consequences did. Assault involving family violence is already serious, but when there's a prior conviction, the law escalates the charge automatically. That's not opinion. That statute, the defendant keeps insisting this should be a Class A misdemeanor, but the judge explains, more than once, that prior convictions strip away that argument entirely. The system is designed this way on purpose. Repeat behavior triggers harsher penalties to protect victims and deter future harm. This isn't about one incident in isolation. It's about a documented pattern. And courts don't pretend patterns don't exist just because a defendant finds them inconvenient.
Me or poison me or do something to me.
No, sir.
So
No, sir.
I'm not asking for a pure bond, I'm asking for a bond reduction.
Okay, Mr. Cuba, I'm not setting a bond because you failed to appear to court. When you fail to appear, the court's not going to set you a bond
I
anymore.
didn't fail to, so let me ask you this, Ms. Blake. When was this actual court date? Can you tell me that?
Okay, Mr. Cuba, we have that other indictment. I'm happy to pull that up for you.
Or
But there
would
was
you
a date
please,
certain.
would you please pull that up for me, please, ma'am?
Yeah, one moment. All right, so here's the indictment. And I'm also going to go to any other information that we have. Now, what you have to remember is, now listen, Mr. Cuba, your attorney is gonna, Mr. Cuba, if you're not listening, you're not understanding what information I'm trying to share. Your attorney is going to show you what information that the state has or does not have. And we're actually going to also have you here on that November 6th date. So you'll be able to go over all of it. And then you'll know the strength or the weakness of the state's case. But this is the allegation that you failed to appear on November 9th.
So where's the date? Where's the date down here for me to appear in court?
Sure, sir, let me show you these
Where's the
dates.
card number? Why is this
Mr.
filed 5 months later?
Mr. Cuba, if you'll look and see some of the documents in response to your questions, you received a PR bond. And then 5 months later, the state returned the, now look, the state returned the indictment in that assault case. And then we go on forward.
6 months later?
Okay, we go forward. Yeah, Mr. Cuba, if you're not going to listen, I'm going to have to mute you because I need to get you the information. Okay. Now, there was a bond that was set, and here's.
This moment right here is where denial meets documentation. The judge doesn't argue, she shows. The indictment spells it out in black and white, assault of a family or household member with a previous conviction. That single phrase changes everything. What's especially important is how the judge walks through the prior conviction, including the date, court, and cause number. This isn't vague. This isn't hearsay. This is verified court history. And once it's on the record, there's nowhere to run from it. For viewers unfamiliar with the system, this is why prior convictions matter so much. They're not just background noise, they're legal multipliers. And as you'll see in the next section,